Please be seated.
Good morning. Court is in session. A representative of the registry, please call the case.
Thank you, Madam President. Trial Chamber 2 of the International Criminal Tribunal for Rwanda, composed of Judge Tagrid Hikmet, presiding, Judge Zeon Kipak, and Judge Joseph Masanche is now sitting in open session today, Monday, the 1st of November 2010, for the delivery of the judgment in the matter of the prosecutor versus Gaspard Kanyarukiga, case number ICTR-02-78-T. Thank you, my lords.
Thank you. Prosecutor, Mr. Jallo, please enter the appearance of your team.
Good morning, Madam President, Your Honors. With me are the Chief of Prosecution, Richard Karegeza, Polo Makwaya, Senior Appeals Counsel, Althea Windsor, Sheikh Mara, and Lansana Dumbuya, as it pleases your lordships.
Thank you, Mr. Jallo. Defense, Mr. Jacob, please enter the appearance of your team.
Morning, Madam President, Your Honors. My name is David Jacobs, lead counsel for Mr. Kanyarukiga. With me is my co-counsel, Claver Sindiagaya, assistant Ian Edwards, investigator Jean-Martin Ndahirwe. May it please the court.
Thank you. Mr. Gaspard Kanyarukiga, are you able, you hear the proceedings in the language you understand? Thank you.
Yes, Madam President.
The trial chamber will now deliver the oral summary of its findings in the case of prosecutor versus Kanyarukiga. The accused in this case, Gaspard Kanyarukiga, was born in Kivomo Commune, Kiboye Prefecture, Rwanda. In 1994, Kanyarukiga was a businessman who owned a pharmacy in the Nyange Trading Center, located in Nyange Sector, Kivomo Commune, Kiboye Prefecture. The accused is charged with genocide and, in the alternative, complicity in genocide, in addition to extermination as a crime against humanity. Kanyarukiga is alleged to be criminally responsible under Article 6.1 of the statute and as a part of joint criminal enterprise. The charges in this case are set forth in the prosecutor's amended indictment, which was filed and confirmed on 14th of November 2007. The defense disputes all charges and raises a defense of alibi. By way of background, the events in this case concern alleged attacks on thousands of Tutsi civilians who took refuge at the Nyange Parish, located in Kivomo Commune, Kiboye Prefecture. After the death of President Hapirimana on 6th of April 1994, the attacks culminated in the destruction of the Nyange Parish Church on 16th of April. At the time of the destruction of the Nyange Parish Church, it is alleged that about 2,000 Tutsi civilians were confined in the church and that its destruction resulted in their deaths. The trial commenced on 31st of August 2009 and closed on 24th of May 2010 with the hearing of a closing argument. During the course of the trial, the prosecution called 11 witnesses while the defense called 23. The chamber is unanimous with respect to all three counts of the indictment: genocide, complicity in genocide, and extermination as a crime against humanity. The following is a summary of the central findings concerning the allegations against Kanyarukiga. Only the written judgment is authoritative. It will be available in due course. Firstly, the trial chamber will address evidence it has not considered for notice reasons. The chamber issued a decision on 15th of January 2010 regarding a defense motion for a stay of proceedings or exclusion of evidence. The chamber reserved its decision with regard to a number of requests for exclusion of evidence relating to meetings the accused is alleged to have attended. For the reasons outlined in the judgment, the chamber has not considered the evidence of the prosecution witnesses CBR and CDL regarding Kanyarukiga attending a meeting at the Nyange Communal Office on 13th of April 1994. Witness CBK regarding Kanyarukiga's attendance at a meeting at the parish on 13th of April 1994. Witness CDL regarding Kanyarukiga attending a meeting at the Matanoga Center on 14th of April 1994. Witnesses CBR and CDK regarding Kanyarukiga attending a meeting at the Kudikuki building on 15th of April 1994, and witness CDL regarding Kanyarukiga participating in a meeting outside his pharmacy on 16th of April 1994. For the reasons outlined in the judgment, the chamber has not considered this evidence because it finds that there was insufficient notice of this evidence provided to the accused by the prosecution. In addition, for the reasons outlined in the judgment, the chamber has not considered a number of other pieces of prosecution evidence in its deliberations, including evidence of the accused attending other meetings on the basis that there was insufficient notice provided to the accused by the prosecution. Turning now to the trial chamber's assessment of the alibi. The indictment alleges that Gaspard Kanyarukiga engaged in criminal conduct from 10th of April to 16th of April at the Nyange Parish Church and surrounds. The defense has provided an alibi for the period of 12th of April to 16th of April, which places Kanyarukiga in Gitarama and Ndera just outside Kigali during this time. The defense claims that Gaspard Kanyarukiga left Nyange and stayed in Gitarama from 12th of April 1994 to 14th of April 1994, whilst he endeavored to organize documents for a travel to Ndera to retrieve his family. It further submits that Gaspard Kanyarukiga left Gitarama early on the morning of 15th of April, passed by Gitarama military camp to pick up a soldier escort and proceeded to Ndera, stopping at witness KG55's house, witness Hitimana's shop in Kigali, and at a roadblock in Ndera. On 16th of April, the day that the Nyange church was destroyed, Kanyarukiga is said to have traveled from Ndera to Nyange with his family. Via an alternate and longer route than that was taken on 15th of April 1994. The defense presented 13 witnesses who claim that they saw Kanyarukiga on at least one of these days. The notes that the following factors in combination lead it to reach its conclusion with regard to the alibi. Firstly, the defense filed its notice of alibi after the close of the prosecution case. Further, a complete list of defense witnesses who would testify in favor of the alibi was filed only 1 month prior to the start of the defense case. The Chamber has taken this delay into consideration in determining whether to attach any weight to the alibi evidence. Secondly, for the reasons set out in the written judgment, the Chamber does not find the defense witnesses who provided evidence with regard to the alibi to be credible. Among other things, the Chamber found many of the defense witnesses would have a reason to provide testimony that was favorable to the accused and found their accounts insufficient to raise doubt with respect to the prosecution evidence. Finally, the Chamber has carefully considered the observations recorded during the site visit, which was undertaken by the Chamber from 19th of April to 21st of April 2010. Comparisons between the observations during the site visit and the defense witness evidence further confirm to the Chamber that the evidence given by defense alibi evidence is not credible. In addition, these comparisons show that the route purportedly taken by Kanyarukiga on 16th of April 1994 was long, precarious, and would not reasonably have been taken at all at that time. In combination, these factors, for the reasons set out in the judgment, lead the Chamber to find that the alibi is not reasonably possibly true. The trial chamber will now address the allegations that the prosecution has established beyond reasonable doubt. The indictment alleges that after the death of the Rwandan president on 6 of April 1994, Tutsi civilians were attacked in their homes in Kivomo commune, and that as a result of these attacks, Tutsi civilians sought refuge in public buildings, including Nyange Parish Church. The indictment further alleges that from 12th of April 1994, attackers surrounded the Nyange Parish at which Tutsi civilians had taken refuge, and that Hutu assailants attacked the Tutsi at the Nyange Parish on 15th and on 16th of April, culminating in the destruction of the Nyange Church by bulldozer on 16th of April. As explained in the judgment, the chamber finds that the evidence consistently establishes that after the death of President Habyarimana, Tutsi civilians sought refuge from attacks at the Nyange Parish Church. It is further established that Hutu assailants surrounded the parish after 12th of April 1994. Further, although not explicitly alleged in the indictment, the chamber has found that attacks against the Tutsi at Nyange Parish began on 13th of April. The chamber has no doubt that the attacks intensified on 15th of April, and that at least one grenade was thrown during the later part of this day. Following this, the Tutsi locked themselves in the Nyange Parish Church. The chamber finds that there was an attempt to burn down the church in the afternoon of 15th of April. When that was unsuccessful, on 16th of April, at least one bulldozer was used to destroy the Nyange Church, killing approximately 2,000 Tutsi civilians who had taken refuge or who took refuge inside. The chamber now moves to a series of allegations regarding the accused's role in these events. First, meeting on or about 12th of April 1994. The indictment alleged that on or about the 12th of April 1994, Kanyarukiga attended a meeting on Athanas Siromba's balcony at the Nyange Parish, relying on prosecution witnesses, CBS and CBN, and for the reasons set out in the judgment, the chamber finds that Kanyarukiga, Fulgence Kayashima, Girigorin Dahimana, and Brigadier Mbakirera attended a meeting at the Nyange Parish, but that this meeting occurred on 14th of April. However, the chamber finds that the evidence is insufficient to establish beyond reasonable doubt that the meeting occurred on Siromba's balcony. Second, presence and role in attacks on 15th of April 1994. The indictment alleges that on 15th of April 1994, there were a number of attacks throughout the day against Tutsi civilians taking refuge at the Nyange Church, including the throwing of grenades, which culminated in an attempt to burn down the church with Tutsi civilians inside. The indictment alleges that Kanyarukiga ordered and instigated the attackers during the morning of 15th of April 1994, and that during the later part of the attacks and the attempt burning of the Nyange church, Kanyarukiga was present, ordering, instigating, and supervising and aiding and abetting the attackers. For the reasons set out in the judgment, and based on the credible evidence of witnesses CBR, CBN, CBS, and CBY, who corroborate the evidence of witnesses CNJ, CBT, CDK, YAU, and CBK, that chamber finds that Kanyarukiga was present at the Nyange parish prior to 11th a.m. on 15th of April with Fulgence Kayashima and Grigorin Dahimana. It further finds that on the same morning prior to and during the attacks outlined in paragraph 14 of the indictment, Kanyarukiga was around the areas of the state of the statute of Virgin Mary and the Nyange Church. Moreover, based on witness CBR, who the chamber finds credible, the prosecution has established beyond reasonable doubt that Kanyarukiga was present when Grigorin Dahimana told the attackers to begin work, which was understood to mean kill the Tutsi. Relying on witnesses CBY and CBS, who corroborate the account of witness CNJ for the reasons set out in the judgment, that chamber has no doubt that Kanyarukiga was present at the Nyange parish in the company of Fulgence Kayashima after the attacks outlined in paragraph 15 of the indictment. For the reasons set out in the judgment, that chamber finds it established beyond reasonable doubt, based on the evidence of witnesses CBY and CDK, that Kanyarukiga discussed with Fulgence Kayashima on the evening of 15th of April that the assailants should demolish the Nyange church. Demolition of the Nyange church. With regard to 16th of April, the indictment alleges that Gaspard Kanyarukiga, Fulgence Kayashima, Telesfor Ndongotse, Habi Yambere, Grigorin Dahimana, and others met Father Athanas Siromba at the Nyange parish and informed Father Siromba of their decision to demolish the church. It alleges that Kanyarukiga instigated the demolition of the church by suggesting that another church would be built. Finally, the indictment alleges, among other things, that Kanyarukiga was present during the demolition of the church and instigating attackers to kill the Tutsi. Based on the evidence of witness CDL, as corroborated by the evidence of witness CBY and CBR, who the chamber has found credible, and for the reasons set out in the judgment, the chamber finds that the prosecution has proven beyond reasonable doubt that on the morning of 16th of April, Kanyarukiga, Fulgence Kayashima, Telesfor Ndongotse, Habirembere, Grigorin Dahimana, and others met Father Athanas Siromba at the Nyange parish and discussed demolishing the church. Based on the chamber's view that witness CBR gave credible evidence, the prosecution has established beyond reasonable doubt that Following this meeting, Kanyarukiga told Burgmeister Ndahimana, IPJ Kayashima, Judge Habirambere, Ndongotse, and others that the Nyange Church had to be destroyed and that he would make it his responsibility to build it in 3 days. The Chamber notes that it has found that the Nyange Church was destroyed following these series of events. Finally, the Chamber finds that the prosecution has failed to establish all other allegations contained in the indictment that relate to the accused, the deliberations regarding the allegations, and associated facts that the prosecution has failed to establish beyond reasonable doubt are discussed fully in the judgment. The Chamber's legal findings, having considered the facts established by the prosecution, the Chamber is satisfied that Gaspard Kanyarukiga and others planned certain criminal conduct that was later perpetrated. The plan to destroy the church substantially contributed to the killing of the Tutsi at the Nyange Parish on 16th of April 1994. That the accused had the intent to plan the destruction of the Nyange Church, and that Kanyarukiga was aware that if the planned demolition went forward, the Tutsi who had taken or who took refuge in the Nyange Church would be killed. Therefore, for the reasons set out in the judgment, the Chamber finds beyond reasonable doubt that the accused and others planned the destruction of the Nyange Church and the killing of those inside. Given the manner in which the attacks were conducted, the Chamber finds that the assailants intentionally targeted and killed members of the Tutsi ethnic group, a group protected under Article 2 of the statute. The Chamber also finds that in planning the destruction of the Nyange Church on 16th of April 1994, the accused is responsible for the killing of approximately 2,000 members of the Tutsi ethnic group. The Chamber, therefore, finds that the actus reus for genocide has been satisfied in this case. Furthermore, having considered the totality of the evidence, the Chamber finds it established beyond reasonable doubt that Kanyarukiga acted with genocidal intent. For the reasons set out in the judgment, the Chamber, therefore, is satisfied beyond reasonable doubt that Gaspard Kanyarukiga is criminally responsible under Article 6.1 of the statute for planning the killing of members of Tutsi ethnic group at the Nyange Church, and is therefore guilty of genocide, count 1 of the indictment under Article 2(3)(a) of the statute. Having found Gaspard Kanyarukiga guilty of genocide, the Chamber dismisses count 2 of the indictment, charging Kanyarukiga in the alternative with complicity in genocide. With regard to extermination as a crime against humanity, the Chamber is satisfied that the demolition of the Nyange Church was committed as part of a widespread or systematic attack against the Tutsi civilians population on ethnic grounds, and that the accused knew that his acts formed part of this and the accused knew his acts formed part of this broader attack. Further, having found that Gaspard Kanyarukiga intentionally participated in the planning of the demolition, which resulted in thousands of Tutsi deaths, the chamber finds that the accused intentionally participated in a mass killing of Tutsi civilians amounting to extermination as a crime against humanity. Accordingly, for the reasons set out in the judgment, the chamber finds that the accused is guilty of extermination as a crime against humanity. Count 3 of the indictment under Article 3 of the statute. The chamber will now turn to its findings in this case. The trial chamber finds, in respect of Gaspard Kanyarukiga, as follows. Count 1, genocide, guilty. Count 2, complicity in genocide, not guilty. Count 3, extermination as a crime against humanity, guilty. Mr. Gaspard Kanyarukiga, please stand up. The chamber has considered the gravity of each of the crimes for which Gaspard Kanyarukiga has been convicted, as well as aggravating and mitigating circumstances. The chamber sentences Gaspard Kanyarukiga to a single sentence of 30 years imprisonment. In accordance with rules 102A and 103, Kanyarukiga shall remain in the custody of the tribunal pending transfer to the state where he will serve his sentence. This marks the end of the summary of the judgment. The full judgment will be available soon. The trial proceedings in this case have now come to an end. Thank you. The court now rises.
All rise.